Understanding the notice of allowance and what it means is important for trademark applicants who file an intent to use application. An application filed under intent to use that gets approved by the USPTO initially and then gets published in the public record without any opposition or extension filed will then be issued what's called a notice of allowance. The notice of allowance now says that the application is essentially ready to register as soon as acceptable evidence of use is submitted by the applicant. The applicant has up to 3 years from the date of the notice of allowance to submit that acceptable use. However, the chunks of time allotted by the USPTO are in 6-month increments, and you need to file extensions. For example, after 6 months, if you don't yet have evidence of use in commerce and you want to continue the application, you have to file an extension to get another 6 months. And the extensions can total up to 3 years. And the government charges a filing fee for each extension. When you are ready to file evidence of use, because the mark is now being used commercially with customers, with the public, that'll vary slightly depending on whether the application is for goods or for services. If it's for services, the types of use that are generally acceptable are marketing materials or advertising materials, which can easily include a web page about the service. It can include a brochure. It could sometimes include a business card if it references the service. Say you're a realtor or an attorney, and the business card makes some reference to the actual nature of the work, as well as the brand, the trademark of the brand name. That would generally be acceptable. If the application is for goods, then the evidence of use will generally need to show the trademark used on the product itself, and that could be on a label or on the packaging. Essentially, it needs to be somewhere in physical proximity to the actual good or product itself. There is, however, a type of online specimen that may be acceptable for goods, which is where the goods are being sold online and you have a screenshot that also includes the mechanism to purchase the goods. So a shopping cart button or something of that nature can be acceptable screenshot evidence for goods. So it's important to know when your deadline is for filing the evidence, or when your next deadline is, absent an extension. And then when you do file the evidence, one other important thing is that you're filing a declaration as well that states that you are using the trademark in connection with all of the goods and services that are still listed in the application. So it's possible to remove some of the goods or services if they are not currently in use. And another element of the filing of the statement of use is also the date that the trademark was first used internally or anywhere, and the date that it was first used in commerce, meaning with the public in sales or in public advertising once there had been business conducted in connection with the trademark. So notice of allowance is a wonderful step for an intent to use application, but there are still these important hurdles to clear in order to complete the registration process.